Panel up, so I don't know if that makes us the premiere or the guinea pigs, but we're here, and we're going to try to wake you all up. My name's Michael Sukin. I've introduced my panelists briefly. As we said, we're not supposed to do bios, but Professor Mihai Fixor, Richard Owen from the WIPO, Professor Hugh Hansen. Our panel, the application of international treaties to collective management rights, really breaks down into three sort of subjects, most of which we'll get to. One is the nature of the rights concerned, technological protection measures, and rights management information. Sort of the challenges ahead, system interoperability, market access, numbering systems, which Richard will address at the end. Then there's the European collective management issues and competition measures and how that works in the international arena, which you and Mihai will address. And I just wanted to say, just briefly to start, that if you look at each panel in this 2.5-day conference on collective management, you see an attempt to discuss how music works are managed and how the productivity of musical works can be enhanced and protected through collective management. And what are the political and economic and cross-border forces impacting these rights and these initiatives? In this day of copyright minimalists and copyright maximalists, which didn't exist when I was in law school, it seems to me that there's an assumption in this whole group of conversations about the inherent value of copyright. Copyright is worth protecting, in part because those that have created it contribute uniquely to the cultural foundation of this country, of Europe, of the world, because the contribution, however it manifests itself, however it's distributed, however it's exploited, is worth protecting. It's worth protecting for all the reasons that all of you know. Music, books, film, painting, all the contributions to the collective culture of the world are, in my view, the private property of those who create them. They have the right to protect them. They have the right to decide how they will benefit from them, how they will be distributed, and who, if anyone, will exploit, enhance, or promote them. Those that invest in the development, the exploitation, and the distribution of copyrighted works anticipate a return on their investment, and society benefits from the incentive of these companies and individuals to continue to enhance the economy and culture of the world, if you will. As we get into our panel, a few things to keep in mind, which is, can the law and the technological protection measures really keep pace with digital innovation? The question that you should be thinking about is, the American paradigm of collective management relevant at all in Europe and elsewhere? Are the systems in place and the technical protection measures in place sufficient to monitor the world's repertoire? So with those, no doubt, stimulating thoughts in mind, I'm going to turn over to Professor Fixor.
Thank you, Michael, for this clear and challenging to us to the speakers in the panel. My topic is very close to the title of the panel, the application of international treaties in relation to collective management. I will speak mainly about the first issue in the list of issues to discuss, nature and scope of rights concerned by collective management. This issue emerged with increasing emphasis in WIPO in the middle of the 1980s, just at the time when I joined the organization where 14 years as director and assistant director were in charge of copyright. Now I do not work in WIPO, but I still like to speak about those discussions in which I very much was involved. Also because before that I had been for 10 years the Director General of the Hungarian Author Society Artists. So I don't have to say that the views expressed by the speaker are not necessarily the views of the organization. I may say that if you find something in the views of the speaker you don't like, those are not necessarily the views of the speaker. The reason for which in the middle of the 80s collective management received more attention in WIPO was the obvious reason that this form of exercising rights was becoming ever more widespread, ever more important. At that time, not only the traditional fields were covered, such as musical performing rights, mechanical rights, to a certain extent thematic works, but also in many countries the communication public performing rights of phonogram producers and performers, and then reprographic reproduction, the right to remuneration for private copying and cable retransmission. So in an organization which administers international treaties, the issue was in a way necessarily emerging. What are the conditions, criteria, if any, for a collective management system in order that it may be in accordance with the obligations of the country concerned. And this issue was discussed first. Some delegations were a little bit surprised and said that why on earth we deal with this, because there is no provisions in any international treaties about collective management. So this is an issue for the owners of rights. They may set up such systems if they want to, and they should take care of them. But very, very, very quickly it became obvious to everybody that this is not so simple as this. As long as owners of rights establish such systems voluntarily, of course this argument is fully valid. But at that time there were already several national laws which prescribed mandatory collective management of certain rights. There were some others, mainly at that time the Nordic countries in Europe, which also introduced so-called extended collective management systems. This means that the national law extends the effect of a license given by an organization established voluntarily also to those who haven't joined the organization. Now, this was really a quite substantial issue. The issue was whether or not such intervention by national legislators in the exercise of exclusive rights was in harmony with international treaties. We have heard what Michael has said about the proprietary nature of copyright. This must be up to the owners of rights to decide whether they authorize or not certain uses. And from the viewpoint of this question, we have to recognize that collective management, particularly fully fledged collective management systems, extending to monitoring, establishing tariffs, licensing, collection, distribution, inevitably include certain limitations of the possibility of owners of rights to decide whether they authorize certain uses, under what conditions, and against what kind of remuneration. So, in a fully fledged copyright system, these elements are uniform. If somebody is part of the system, has to accept them. if these conditions are accepted voluntarily, of course there is no problem whatsoever with the exclusive nature of the rights involved. And such systems are very much beneficial, not only from the viewpoint of the interest of owners of rights, but also for users. This is not the case, however, necessarily or in general, not the case when mandatory collective management is prescribed. The prescription of mandatory collective management is clearly a condition of exercising the exclusive rights concept, a very substantial condition, since it excludes the freedom of choice of owners of rights between various options, and because such mandatory systems quite frequently are coupled with the appointment of licensing of one organization in the given country only, and also with the heavy intervention of the government in the establishment of the tariffs. So it's not far away from a compulsory licensing system. If we recognize that this is a condition, it is very much relevant that in the Berne Convention there are only two provisions which allows member states of the Union to impose conditions for the exercise of exclusive rights. The first one is Article 11 bis 2, which authorizes members of the Union to determine conditions of exercising the right of broadcasting, rebroadcasting, and retransmission by cable. And the other one is Article 13 about mechanical rights, which also has got the language of imposing conditions of exercising this right under certain conditions. In general, these provisions are regarded as a legal basis for the introduction of compulsory licensing. But these provisions do not speak about compulsory licenses, about establishing conditions. Not only a compulsory licensing system is a condition, as we have seen also mandatory collective management is a condition. And because the Berne Convention only provides in these provisions for the possibility to impose conditions of the exercise of an exclusive right, it follows from the a contrario principle that in other cases it doesn't authorize it. Doesn't authorize, for example, such mandatory collective management in the case of public performance right under Article 11, or of course the right of adaptation under Article 12. And in the so-called WIP Internet Treaties, the making available to the right in general may not be subject to mandatory collective management, but it's a little bit more complex. Many people consider that I am the author of this so-called umbrella solution, which was included in the two treaties, one on copyright, the other one on related rights, and I'm ready to claim authorship. The more so because I am not so proud of this solution. It was called umbrella solution because it covers both streaming and downloading, and also uploading, of course, for these purposes. And the advantage of the solution was to avoid legal characterization, to offer a neutral language, making available to the public of works by wireless means in a way that members of the public may access them from a place and a time individually chosen by them. A neutral description of the online transmission of works. Now, in the two treaties, also provisions were adopted about exceptions and limitations. And the basis of the three-step test, I don't have time to deal with the three-step test. But in addition to that, also an ugly statement that the exceptions existing in the traditional analog world may be extended to the new environment. For example, this is the basis for extending the mechanical rights compulsory licensing in the U.S. Copyright Act, Section 115, to online delivery of music. Now, I think that this solution should be now called rather a carpet solution, because we have swept so many things under the carpet, and now that we have to walk on that, it is quite bumpy. And the characterization of these transmissions, whether it is performing right or right of distribution, now with this decision of the Southern Court, time passes so quickly. It's a political hot potato. I don't have too much time for the rest of the topics, and I cannot speak about how all these things are reflected in the European directives. The right to remuneration is another thing, because there is no authorization. So when the right is just the right to remuneration, then mandatory collective management not only possible in certain cases, the only way, for example, in the case of the right to remuneration for private copying. Extended collective management is a solution to the problem which emerges in certain cases concerning blanket licenses. Blanket licenses are blanket licenses, but not based always in respect of all objects of protection to previous authorization given to the collective management organization. There are some cases not covered. So in certain countries, the national law extends the effect of the compulsory license also to those who are not members of the organization. Now, as long as this only covers marginal cases, it seems to be acceptable. Unfortunately, in certain countries, it was the case, for example, in Russia, some 4 or 5 people came together and said that now we form an extended collective management system. We'll authorize all the audiovisual works of the world we collect, call ourselves a collective society. We will not speak about distribution. So this is not an acceptable solution. The other is, and for example, this is also clear on the basis of the satellite and cable directive in Europe, that there must be, in such a case, a possibility for opting out. I only have 1 minute for the other topic I covered in my outline, and this is the question of deduction of remuneration for cultural and social purposes. In certain countries, there is a kind of obligation for this. For example, Germany is very close to this. It's clear that from the viewpoint of the international treaties, it's not acceptable to, in a way, confiscate part of the remuneration due to foreigners. It's another matter that this may be useful to promote creativity in these countries and to get political support for copyright. But all this should function on the basis of direct or indirect authorization of the interested owners of rights, on the basis of the Roman principle, nemo plus juris ad alium transferet potesque ipsa habet. Time is up. Thank you very much.
Where's Larry? I don't like these cards at all. I just really...
Shall I distribute it?
No, just you can just hold them up for us. We don't need them, you know.
Yeah, right. We have some time now. The way we've organized the panel is we have time now for questions on the subjects that Mihai has raised, which can be either exactly on what he's asked, or anything you feel like talking about relative to collection societies, and particularly with regard to restrictions in antitrust. So if you've got questions, this would be a good time to raise them. And while you're thinking about them, I'll want to promote some discussion here, which is, Mihai used the word with regard to social and cultural deductions as confiscations, which a lot of Americans think they are. when it comes to European societies. And I'm wondering whether either Mihai or any of the other panelists feel that there is any apart from treaty questions, is there any violation of antitrust laws raised by the cultural and social deduction issues in your view? The answer may be no or yes, but I'm just curious. Or any other way that these are maybe inappropriate in a European context.
So time is not up?
And that time is not up.
I think that, perhaps I have put a little bit too much emphasis on this conflict business. I also like to emphasize that this is very useful for small countries and developing countries to show that copyright functions as advertised, that is, for the promotion of creativity. It's a very good argument that we should look at that. We not only collect for the others, we also keep a certain percentage and we use this for the promotion of creativity in this country. So even if it would be really a violation of international obligations to deduct a certain percentage, or it may be just a tax, but then it should be covered by agreements on the avoidance of double taxation, and it's very rare that taxation is made at source. As far as anti-competition aspects are concerned, yes, of course, you may speak about that if there is only one society and it misuses its position to establish this condition. But there are many other aspects of such laws. And then we are already at the famous recommendation adopted by the European Commission in May 2005, which raises a lot of issues which I don't like.
Okay. Anybody else? I just want to carry this one step further. In terms of transparency, Mihai mentioned that theoretically the cultural and social deductions are done with the permission of the people who are supposed to be receiving the money. And I wonder if in practice that's correct. Are they just assumed a part of a tithe of some sort to the society? Or, I mean, is there really a choice?
No, I think that there is no real choice in the case of domestic owners of rights. When they join the organization, it's frequently take it or leave it, so they have to accept that there is such a system there. It is a choice. Case of bilateral agreements. SESAC model bilateral agreement which includes this possibility, the 10% deduction, but before concluding an agreement there is still negotiation, and I understand that there are some organizations which would like to limit this or increase this 10% level. In this case, it's not automatic.
Okay. Anybody else? Oh, yes, sir. Sorry, please. Do you need a mic? Yeah.
I think I'd like to say a few words about that. First, let's be clear that an author, a composer, doesn't have to belong to the society in his or her country. If the person is not happy with the deductions policies or other policies of the national organization, that person is free to move his or her rights to any of the organizations that manage the rights, including in Europe. So let's not be under the false impression that you are completely bound by the policies of the organization in your own country. Second, the negotiations that merely alluded to between organizations are all different. The 10% that are in the SESAC model contract are a limit, a maximum, and there are lots of different situations. So there is clearly a possibility for organizations within SESAC to make their opinions heard. I'm sure that there are as many situations as there are bilateral agreements. And third, it's always been a difficult issue, of course, because it touches on the kind of inherent relationship between the societies around the world. In the reciprocal agreement system, you entrust your management of your rights to another party that you can't influence its governance, so you depend on that party. But lots of organizations recently have realized that those deductions, especially the cultural ones, provide goodwill in so many ways that per capita collections in the countries where it's practiced are significantly higher. So there is no clear-cut vision about the pros and cons of those deductions, and it's really an issue that is in flux. So let's make sure that we don't have black and white ideas about those deductions. They are shades of gray, I believe.
Well, far be it from Americans to have black and white ideas about social deductions. I mean, certainly that'll never happen. But
of course not.
Right. I do have a question about your first point, which is if one changes society and goes to a society where there are no deductions, nevertheless, if you earn money at a source where there's a society which has deductions, aren't they taken off the top before the distribution is made to your now new home society?
As I said, there are as many situations as there are bilateral agreements, but at least the society, you can make your opinion heard. And if there are a significant number of people that decide to move out of their national organization, which is, of course, less convenient because of those deductions, it probably would send a signal. I don't believe that that's the reason why people move out of their national organizations. It's usually because their works are more performed or used in another forum. But the possibility is there, and there are different kinds of members, individual members, physical persons, and also legal entities, and maybe legal entities have a different vision.
Yeah, I want to be clear. I'm not expressing opinion. I'm just trying to provoke discussion here, you know. Okay, if everybody has a question. Sir, over here. Could you identify yourself, by the way? Would you mind? Is there a mic? There's a mic somewhere. I hope we got to get her. I hope you did your jogging this morning.
Mario Bouchard, General Counsel, Copyright Board, Canada. Question is for me. Based on the assumption that there must be some form of regulation of collective management organizations, would you rather that they be regulated by antitrust authorities, as in the United States and in Europe, certainly at the European level, or by a specialized agency like the Copyright Board in Canada?
The second option, very short answer. I would be in favor of the second, the specialized agency, which takes into account the special aspects of collective management. General principles of competition law which apply to copyright may result in certain consequences which may undermine the system as it happens frequently in Europe.
I may be wrong about this, and maybe Fred can straighten me out, but I'm under the impression that the people that supervise from the Justice Department and the courts in America are very aware of all of the issues because it's almost a specialized tribunal at this point. Am I wrong? Or? Sorry. I don't mean to put you on the spot, but
thanks, Mike. I'm Fred Koenigsberg, counsel to ASCAP. I think we have to break down your question to two parts. In terms of our friends at the Antitrust Division of the Justice Department, their contact with us,
friends.
Their contact with us is relatively infrequent, and therefore they don't really have the detailed day-to-day knowledge of an agency. Their task is very different from the sort of supervision that we're talking about here. In terms of the court, which ASCAP operates under by virtue of the consent decree that it entered into, that court's task is also relatively limited. That task is to set the rates and terms of license agreements if the parties cannot agree to them. And therefore, again, while the court is somewhat familiar with ASCAP's operation, in large part because the judge who has the jurisdiction over the consent decree has been the judge since 1975. Nevertheless, because the task is relatively limited, the detailed, granular, if you will, knowledge that I think Mihaly was talking about really doesn't exist in either agency. Not that that's a bad thing.
Oh, there's a question in the far back there.
Hi, Ron Gertz. I'm the CEO of MRI and Royalty Logic. I mean, rather than legislation or copyright royalty boards, why not just free up all the collectives to compete with one another? My problem, there are obvious problems with legislation. My problem with copyright boards is the recent ruling of the Copyright Royalty Board of the United States regarding sound recording performances, which ruled that a monopoly is the most efficient way to collect royalties. And having ruled that a monopoly was more efficient, the board ruled that it seemed to make no sense to compel royalty recipients to choose among collectives. And since a monopoly was more efficient, then the issues of administrative cost and the effect of competition on lowering administrative costs was irrelevant. Why not just allow everybody to compete?
One last question and we'll move on, which is I'm wondering whether Mihai or you feel that the compulsory licensing that's being done in Europe is open to challenge. If it's not entirely permitted by the treaties, can it be challenged on an antitrust basis, given the unique position of the societies in each country? Is there any sense to that?
You have said that something which is not permitted by the treaties simply are not permitted by the treaties, and that's our view as basis that in addition is also there are some new forms such as the mandatory price after the transfer of the exclusive right. This is very much under what conditions this is.
Okay. Sorry, last question. Yes, Jenny.
I just have Jenny Vacher, ICMP. One comment on what Eric Batty said and a question for Mihail Fixer. Regarding the cultural deductions, I think, if I may, that the main issue here is that we have to go back to rights holders' choice. If it's rights holders' choice that there be deductions, then I don't think there's an issue. On the other hand, if you do look society by society, many of the non-domestic rights holders whose money is flowing through those societies are not represented in those societies or adequately represented in those societies. Therefore, there is generally in those decisions that are made in respect to cultural and social deductions a discrimination vis-à-vis the non-domestic rights holders that are not represented in compliance with the rules of the societies in those societies. This is probably tied into this governance issue. The question for Mr. Fixer, you did say that you didn't like the EU recommendation on cross-border licensing. I'm sure you're waiting for the question, what don't you like in that recommendation?
Okay, we have just a few minutes.
Very shortly.
Thank you, John.
I do agree with the resolution adopted by the European Parliament, at least on 2 points. Not because the rapporteur was a Hungarian MP, not because she is a dangerously sexy lady, but she was right on 2 points. First, this is an issue which should have been regulated not just in a soft law basis. because there are many directives, at least 4, which contains provisions about collective management. It's really the competence of the European bodies, the European Parliament and the Council to take care of the preparation of such decisions, such important issues. Second is that the recommendation didn't pay sufficient attention to the problem that should be solved somehow. Namely, I don't speak about the legal aspects that certain terms are quite unprecise, may be solved somehow through interpretation. But as we know, if the repertoire is concentrated in 1 or 2 societies in Europe, the most important repertoire is this is a disadvantage for smaller societies and smaller countries with smaller repertoire. And they may be in a kind of unpleasant situation to offer less to the authors in those countries. May undermine the support for copyright in those countries. So some kind of solution is needed for that. There was no sufficient thought given to that problem. I hope that the collecting societies will solve this somehow. I'm confident.
Okay, I'm going to turn the floor over to Professor Hugh Hansen. We're going to follow somewhat of the same format, presentation and time for questions. If there's something we didn't get to, we'll try to get to it at the end. Hugh?
Thank you, Lloyd. I'm very happy to be here. I want to appreciate the invitation from Mike, Larry, and it looks like a fantastic conference with great turnout with some very, very interesting issues. Topic I have is basically European collective management organization facing competition measures or European competition measure on the fact of European competition vis-a-vis foreign authors, societies, and publishers. And I actually did a fairly long outline that goes through international norms, the U.S., a bunch of other stuff going through almost every aspect of it. And as I was looking at last night, I really don't know competition law, so more difficult for me. That was a joke. But I actually do have background in it, which I started out as an antitrust lawyer and actually law school worked in antitrust division. I think when I worked in the Second Circuit, I was actually working for the Judge Gerfine when he decided the infamous CBS v. ASCAP case, which in the Supreme Court was PMI, BCS. And I know people, the ASCAP people and their folks here. I mean, just the name Gerfine, the hair on the back of the head goes up, and it's he did rule that against actually the collecting society, reversed in the Supreme Court. He remanded for a reasonable consideration with regard to basically market failure types of situations. And I have been interested in competition law. Actually, it's a subject I think is fascinating, but in the amount of time, actually, there's not a lot of time to go through that. So what I plan to do is just look at sort of a big picture. First of all, what effect does it have internationally? What effect do international norms have? Enough. Europe is surrounded by a moat on this. It doesn't matter what's going on outside of Europe. Europe's going to decide this thing. I don't care what Burns says, what anyone says. This is a European issue which should be decided within Europe, which is most of the way things happen, I think. And so the real key is what's going to happen within Europe. And it's sort of a fascinating issue because you have all sorts of issues that have been in with regard to the European Union almost from the beginning, as well as the interesting issues of new technology and obsolescence and competition on IP and all sorts of things. And what everyone is interested in, I mean, talk about collecting societies and talk to the people. They're energized by it. In fact, I think it's actually a polarizing topic, I might say. But even the Parliament, which used to not get interested in too many things, spoke up and there's a very strong and actually interesting European Parliament. And basically, the big global issues are, I think, one is just the role of the community, the Union, the European Union, vis-a-vis the member states. And this is really, even when you have people who are communautaire, which by the way is a French word, they are actually on the side of, communities stay away from this. This is a member state issue. We know how we're doing. I'm affecting society. We've done it for many years. There's really no need for you to come in here with your new rules. And the community, people in the community are looking at member states the same way they did in the beginning of the European community, which was they're part of the problem rather than part of the solution. And so we have almost a throwback to some early issues of the community in the 70s and 80s and getting the ECJ involved. Second thing is globalization and capitalism versus basically socialism. And the idea that people should be protected from the effects of the market. The big might be bad, multinationals are going to destroy diversity of culture, a lot of things, and it's a defense against market forces which is justified for very solid, good reasons. And actually, the artist and author need protection from larger market forces, also known as record companies. And if you actually look up scuzzy capitalist in a dictionary, definition of these record companies. And so it's a, and also, the other thing is most of these companies have American origins or multinational. The thing that unites all the Europeans on this issue, and I think Americans can be proud of this, is their anti-Americanism. And I think, we've brought the world together a little closer. I don't think very many countries can say that, frankly. And all this, this welfare and social and all these issues, of course, I'm not going to check because it's basically money that should be going to Americans is going to us. So the individual artist, the European artist, is certainly, I would expect, would not. And I think there's a lot of value. It's really basically a redistribution of wealth situation. Socialists, of course, would understand. Market efficiency might not understand. So on every type of issue, you really have how you come in philosophically. Our antitrust laws would not be, I don't think it would be a violation, but they certainly want total autonomy of people to agree whether or not, and then look at it and look at governance and all those other issues. Whereas I don't think this is an issue that competition authorities in Europe are particularly concerned with, other than some sort of form of consent. Then you have free movement of goods, which of course is a tremendous issue with regard. One of the most important. And here you have basically in each member state there's like 6,000-pound gorillas sitting there right in the middle of what used to be called the information superhighway or whatever. Boy, those were the days, huh? When we called it that. I'm almost nostalgic for those days when we used that term. It's so quaint now, really. Now I think it's basically, what is it? It's an escape for IP hijackers information on the internet. Yeah, and what do you do with this person? Each, the horrible thing is you have to clear rights in each country. Can't just, free movement is actually disaster and things are moving in that direction. So you have the people in the internal market, DG internal market, who are particularly upset with this in terms of efficiency, in terms of digital. They are almost hysterical on this issue, actually. But they've run into, they wanted to harmonize this. They had the thing on transparency in government, they had a study, and we're going to have a directive, and then what happened? They ran into member states, and they weren't able to do anything. So you have a recommendation. Whenever the commission comes out with a recommendation, it's a white flag. We've lost, but we've done all the work, so we're going to issue something. So they're upset, I think, because they were unable to do be effective in something that they thought they would, and they think they're particularly right on. But then this is, again, the commission, which is very much like the early United States in the late national government over state government. Martial court is for the states are part of the problem. And basically, community officials basically think the states are often part of the problems. But on the other hand, you have community legislation which either requires or needs or wants collective societies, whether rental rights, satellite cable retransmission, is there royalties directive. Even the Information Society Directive recognizes this and all for it, although it sort of says they have to clean up their act. So you have this free movement thing, which is upsetting to people who strongly believe in free movement, and yet this guerrilla doesn't care. I'm going to sit here and do what you can, take your best shot, pretty much. And so far, the guerrilla in this situation seems to be winning. Then you have competition law. Now, for competition law, this collecting society is almost the worst thing that you can have. One is they're protecting IP. And competition lawyers don't, I got a 5 minute, that's 5 minutes, okay. Competition lawyers and IP is like oil and water. Understand it, they think it's a monopoly and all this other stuff. Have trouble getting their head around it, and so their natural inclination is it should be limited. Horizontal restraint of trade, it would be a per se violation of almost every, whether it's Article 81 or Sherman Act Section 1. It's just like a union, which is a per se restraint of trade. It's competitors getting together and coming up with a price. Of course, good social reasons, that's why I got the Clayton Act exempted unions. Unions were actually sued and lost in Sherman Act cases in the early history of our country. But for good social reasons, they've been exempted. And for the same thing is that there's a special sort of role for collective societies. So you don't have the normal application, but they still want to apply. And one is their de facto, de jure legal monopoly, and it's certainly dominant. In fact, they're super dominant, and therefore normally have to have really strict things. They divide up the market, not good, and is sanctioned by the member states, which most competition people think is anything. So I see I have 2 minutes. So what? A lot faster than I'm looking at. What are you looking at? I'm looking at a watch here. I have 6 minutes.
No.
Slow?
No, you started at 9 o'clock. You're right.
Oh, I thought it was
10
slow.
o'clock.
Hey, look. You can't trust the moderator. Who can you trust?
He wants to get a question.
I know what it was. There was some sort of deal in there, you and Mahali. I know it. Gave him 5 minutes of my time. Right?
See what's in store for me.
Yeah. No, I'm sorry. I got 5. I don't know. This is just like the commission in the member states. No. I got 5 minutes, all right? I can read a watch. You think I'm too dumb to read a watch? No. All right, no. We agree, right?
Actually, it's my watch.
Yeah.
Or was.
Anyway, to get back to the point before I was rudely interrupted. So if you look at the competition issues, we don't have time to go through them all, but whenever it's come up, and this is, basically competition cases like 74, 89, 2002, it's like every 15 years there's some competition cases, and they've all said the same thing. Collecting societies, we got the eye on you, we're not sure what you're doing is right, you got to clean up the act, creating rules, especially on excessive prices and other things which are fairly extreme, haven't really been applied in subsequent litigation. But whether it's the ECJ, whether it's the Commission, which used to be DG4, now DG Competition, very, very, I think, skeptical of what is going on. And perhaps more now, because of the digital age, have been brought in to really be more concerned about things. So it'll be interesting. Of course, they did have these statement of objections. SESAC and everyone's familiar with that litigation. We'll see where that goes. But I think what has happened is that what used to be tolerated in the analog world, we're saying in the digital world we really have to watch it. We may not be able, from our perspective, to be able. I have 5 minutes. I just saw that. What is the future? I think the Commission is on the case, both DG Internal Market, which I don't think is going to have much sway at this point. The Commission, what can they do? They can cause problems. They don't have to go through member states as DG Internal Market does for directors. And depending how strong and how law and economics they want to be, it would be interesting to see what happens. But now there's not even that control. Member state competition authorities now, because the Commission ceded a lot of its jurisdiction, or co-jurisdiction, to member states. And you've seen in Poland and Spain and other places, these local or member state competition authorities have gone to some extent after the competition authorities. And you'd think, whereas you have the member state governments very strong for it, the member state competition authorities, their goal is more efficiency. Their peer group is DG competition, antitrust people. And actually they might want to be able to see that? I still have 2 minutes. What's going on here? All right, so I think there's a very interesting aspect in those member state competition authorities. And the Commission is doing what? Now looking to bring in the U.S.-style system of private actions. Once you start allowing private actions in antitrust actions, well, there's going to be, I expect, a lot of people who will be testing some of the things that the competition collecting societies do. I almost feel like guilty for finishing my thing here, but fortunately, I have nothing left to say. My excuse is you won't let me say it.
Okay.
But
guilt is a good thing.
I think actually the future will be very interesting because I think you have opposing forces that each have power, depending on which venue in and how far they want to go and how far they want to press it. The young Turks and competition authorities want to press it. I'm not sure the old Turks want to press it as much. But I think in the member state area, I don't think much is going to happen in terms of harmonization. In terms of international constraints, I don't think they really, even if they apply, will work. But it presents, I think, a pretty fascinating picture to watch.
Does that mean you're finished?
No, you're right.
For those of you who speak at Fordham, you should remember this little interlude. And I'm going to try to get that watch for April. Yes, we will take questions in the 30 seconds we have left. But I do have a question I want to ask you, which is there is a movement is the wrong way to put it, but there is a direction in Europe of a combination amongst different societies for the purpose of offering online licensing to people who want to go to one group. There's a combination between GEMA and the German Society and the English Society. There's a proposed combination between the French, the Spanish, and the Italian for that purposes. And I'm wondering whether that feels, looks, or smells to you like a violation of competition laws. If you're familiar with it.
Between two societies?
Yeah, or three in one case, yeah.
Yeah, well, one of the, depending how you look at it, one is obviously horizontal restraints under Article 1 and Section 1 are looked at fairly closely, perhaps more than even a dominant position in an application. On the other hand, they're the good guys. They're looking to try to do something in the digital age which is more efficient. And I think anybody who tries to do a one-stop shop or work out a more efficient one, I think the competition authorities will probably lay their hands, very softly and let that go. Because even if you have three doing it rather than one, which maybe they want all three to compete against each other. Three, though, together is better than none. And what really happens, one of the reasons this is technology and obsolescence is the small collecting societies are going to lose out. They're going to be bypassed. And so what you might really have then is a two-tier system. The big get bigger, the richer, and the small survive. If, in fact, there's some room left in them in the analog world of publication, production, broadcasting, which they can still have a role. But the future for the smaller collecting society is grim if you let market forces take hold. And I think member states, especially countries, are going to be particularly careful to protect them, which leads it up to then DG competition, which doesn't need member state courage to bring in actions, how strong they want to do that. My guess is they're going to be very easy on anyone who tries to put together some sort of digital one-stop shop that's efficient.
That's in fact what's happened. Anybody else? I also have a question about transparency in the. I don't know, we're on to Europe, but on the European societies, the Commission seems to vaguely look at the absence of transparency as they see it as an impediment to the free flow of goods and also a sort of antitrust issue. And I wonder whether it would be seen that way here in any way, shape, or form. The societies, ASCAP puts out regular information, but it's fairly dense. BMI doesn't. It's owned by broadcasters. SESAC is a private organization. So the Europeans have made a big issue about transparency and accountability. Here, it seems to be limited, and that's fine. I don't know if that's true.
One of the differences in Europe, use of a dominant position. Europe antitrust law basically is based on a German, U.S. Warren Court model of big is bad. If you're big, then what you need to be controlled is because you're going to abuse your position. You come naturally to abuse your position. So competition rules, as opposed to in the United States where monopolists are actually, you have to actually monopolize even if you have a monopoly. It's a very difficult standard with the idea that monopolists are sometimes the best competitors and innovators. Completely different way of looking at this. So in Europe, abuse of a dominant position, you have two things, excessive prices and also unfair trade practices. So this would fall under unfair trade practices. Anything they do which makes the situation worse. And one is for competitors, if you're not transparent, how can a competitor compete with you? And also for the consumer, which they're looking out for. So I think in Europe, transparency fits more into the law of competition than it does into the U.S. I don't know. I thought actually in the United States they were pretty transparent. I didn't realize that.
Well, you don't have to. But, well, I mean, ASCAP is membership controlled, and you have to be pretty diligent to understand everything that's going on. There's differences between things that are public and things that are private. BMI is effectively privately held, and SESAC is a private company. So I don't know. I don't know what American publishers think, but do they have full access to the societies? I don't think there's too many here this morning, but I think that's sort of an issue. Fox seems to be extremely transparent in terms of how they do business and what they charge and how they go about things because they're dealing day to day with publishers in terms of protecting their rates. I mean, that's just my 2 cents. But I
don't think U.S. would get involved unless there was a silent agreement among the three or two not to be transparent when you get under Section 1. But other than that, I don't see antitrust action.
Any questions? If not, on the competition side, everybody got that straight? Okay, good. We're now going to move to Richard Owen and kind of a more somewhat related topic on TPM and DRM. And so, without further ado,
let's synchronize our watches.
Okay, right. We'll synchronize our watches. 20. Right. Okay.
Right. Yes, this is. Good morning, everyone. A slightly different topic, but an important one because it very much goes to how rights owners exercise their rights in the digital domain. And what we decided I would talk about is the sort of status of implementation of the technological protection measures and rights management information provisions. of the 1996 treaties, that is to say the DRM provisions, technological protection measures and rights management information. More on what those are in just a moment and how they differ. Currently, just like to give you a little data on the treaties. We have 64 members of the WCT, the WIPO Copyright Treaty, presently. 62 members of the WPPT, the WIPO Performances and Phonograms Treaty. I was warned by Michael about using too many acronyms, but as an American, I think most of you are used to it. But those are the two treaties, WCT, WPT, which entered into force in May of 2002. This year, we've had 3 accessions, very interesting. In April, Liechtenstein came in. In June, China came in. And the next month, Australia came in July. That being said, most of the members are developing countries at the moment, so far. A word on expected accessions at the end of my talk. Well, what do the treaty provisions say? Basically, I'm going to summarize here. The TPM provisions require that member states grant adequate legal protection and effective legal remedies against the circumvention of effective technological measures that restrict acts used by authors and that restrict acts which are, I'm summarizing, which are not authorized by the authors concerned or permitted by law. Similar language exists in the WPPT with respect to the rights of phonogram producers and performers in musical performers, not audiovisual performers, which are not covered by the WPPT, at least not yet, not currently. The rights management information provision states that contracting parties shall provide adequate and legal remedies against the removal or alteration of electronic rights management information or the making available of a work or content where rights management information has been knowingly removed. And the relevant articles define rights management information as, quote, information which identifies the work, the author of the work, the owner of any right in the work, or information about terms and conditions of use of the work, and any numbers or codes that represent such information, unquote. More than 100 countries have implemented or are in the process of implementing these provisions. Now remember that there are just over 60 states party. So there's a lot of countries out there that have been working on implementing legislation of the treaties in general, not just these provisions, that are not yet inside. The first implementation was this country, the DMCA, in 1998, followed shortly by the Copyrighting the Information Society Directive in Europe. One other sort of geopolitical word, there is an important push in the form of free trade agreements towards implementation and accession to the treaties by a number of developing countries. There are over 300 FTA, concluded FTAs or FTA agreements under negotiation, primarily between the U.S. and certain third-party, principally developing countries or groups of countries, for example, the Central American Free Trade Agreement, CAFTA, but also the EU and Japan are active in negotiating bilaterals. That include obligations with respect to implementing the treaties, the 96 treaties, but in particular, different approaches, generally going beyond the treaty minima on implementation of the TPM and RMI provisions, going beyond the minimum sort of expression of effective legal remedies, adequate and effective legal remedies to be made available against circumvention and against misuse of rights management information. Separating and distinguishing TPMs from RMI, this is becoming increasingly important, and not just from a sort of juridical or treaty implementation or legislative point of view. The market is beginning to really, really treat differently the two types of technological measures. They together can be grouped under the umbrella of DRM, digital rights management, but they are distinct and they do different things. TPMs, technological measures, generally condition, limit, or prohibit access to or copying of digital content through the application of TPMs. This is what most people think about, including all the consumers who hate DRM when they think of DRM. RMI, rights management information, by contrast, is the metadata that identify content, rights, creators, and licensing conditions. It can also include kind of a hybrid category, which is finger printing and watermarking technologies. Now, they work together because to function appropriately, technological protection measures require rights management information. But as we're beginning to see in the market and in some of the new forms of licensing like Creative Commons, RMI, metadata that identify content rights, parties, etc., are being used in a wide variety of ways that do not necessarily plug into TPMs and are not sometimes even used to apply to protected content protected by copyright. For example, they can be applied to public domain content, financial data, the insurance industry is using rights management identifiers, et cetera, et cetera. So they're completely different and they need to be seen differently, although they are both protected under the treaties. The treaties do not mandate use of these technologies. They are voluntarily applied, but they do require remedies against circumvention and misuse if they are voluntarily applied. Just a word here, we did a survey, WIPO, we did a survey on implementation of the treaties a couple of years ago, which is available on our website and provides quite a lot of information on the specifics of national implementations on all provisions of the treaties, but also in particular these areas. What I'd like to do is basically give you an exemplary list of some of the issues that have come up with respect to implementation of the TPM provisions, because those are the ones that have gotten by far the most attention. Then talk a little about what's happening in the market with development of identifiers, including in the music community, rights management information, the SESAC family of identifiers, et cetera. And then turn to some of the policy issues and trends for the future that we are following that we think are going to be important, namely interoperability, the relationship between rights management technologies and standard setting, and an issue that Mike Keplinger has already mentioned, this sort of balance between application of rights management technologies and public interest uses of works, access to content under limitations and exceptions, how to deal with situations where TPMs may be applied to content that should be available because it's in the public domain or because it falls under a copyright exception. And then finally, a couple of issues for the future that we're following. Basically, the implementation issues that are being followed in a lot of the rights owner industries and their trade associations in this country are very active in advocating and working with developing countries in implementing the TPM RMI provisions, as well as we, the Secretariat, of course, who provide, at request, assistance, technical assistance on implementing legislation to primarily our developing country member states. The first issue is the scope of coverage of the anti-circumvention provision. Should there be coverage of both anti-circumvention provisions for access controls and copy controls, or just access or just copying? Different approaches are applied. More than 50 countries protect against both. Some 30 or so protect only copy controls. And there are different reasons for, I'm not going to go into a lot of detail about what the differences are, but just to point them out at this stage. A second issue is the coverage of preparatory acts. That is to say, in addition to providing for remedies against circumvention of the act of circumvention itself, what about trafficking in circumvention devices and making available manufacture of circumvention devices? Nearly 90 countries currently provide protection against trafficking, but of these, only 60 prohibit trafficking only and don't cover 60 cover both the act of circumvention and trafficking, and about 30 don't cover the act of circumvention separately. Another issue, what about the criteria to prove unlawful purpose of production of circumvention devices? This goes to the way that devices are designed. Whether they're designed for the sole purpose or primarily for the purpose of circumventing, or whether there is a limited commercially significant purpose or use of the device other than to circumvent. You see different standards in different laws. A very important issue, the scope of exceptions and limitations to the prohibition on circumvention of TPMs. A number of policy issues here. Clearly, the need to use TPMs as an anti-piracy mechanism, which is why they were designed and created and are used by rights holders to begin with. The need increasingly to respond to consumer concerns about application of TPMs, because we've seen a backlash, particularly in the music sphere, of dislike and disapproval and unhappiness with the way that TPMs have been applied so far, generally by the record industry, that is clearly affecting revenue and is requiring some further thinking about the granularity and the flexibility of TPMs, and whether there are indeed a need to sort of tailor them or curb in their scope. in reaction to some of these consumer needs and expectations. Whether there's a need to allow circumvention for important social or developmental interests. Now, these can relate to copyright exceptions, but they're not necessarily about copyright exceptions. They're about exceptions to the prohibition on circumvention of TPMs. For example, access controls. There's a triennial rulemaking here in the U.S. under the DMCA where the Copyright Office looks at circumstances, claims that circumvention of access controls are needed for certain public interest reasons. And indeed, there have been 3 proceedings, and we may hear more about it later, where some degree of nuance is being shown that, in fact, there are cases where TPM controls should be, access controls circumvention should be allowed. Related to that, but a very different question, is the relationship between TPMs and copyright exceptions and limitations. This is like privileges that already exist in many laws, allowing users to access and use content without permission, without payment. And this is the DRM lockup issue that you hear a lot about. And it's a very good example relating to collecting societies. We've been talking a lot about Europe. This is a situation that is very much on the agenda of European stakeholders, and that's the relationship between private copying exceptions and levies. Blank recording equipment or recording media levies, which are paid by the manufacturer or by the consumer, in exchange for a pretty broad private copying exception that allows the user then to make non-commercial personal use of copy of music or whatever from an authorized source. And there's language in the directive that says that as DRMs become available and effective in the market, that somehow these levies have to be adjusted. And there's an enormous it's been going on for 4 or 5 years now, discussion, which I'm not about to broach, but will be talked about, I think, in the next panel, because this is a very key issue about how new technology relates to existing collective management structures in respect to copyright exceptions and limitations. Finally, in terms of TPM implementation issues in regard to the treaties, the nature and scope of effective legal remedies. What are we talking about? What kinds of remedies have to be available? And there's a broad spread, civil remedies, administrative, or criminal penalties. I've got 5 minutes. Turning quickly now to RMI. This is really where the music industry has been a leader. There are enormous numbers of identifiers out there that have been developed by SESAC under the Common Information System, or by SESAC in cooperation with the record industry and the other collecting societies and digital music distributors. The interested party identifier is one that's been with us for a while, the ISWC, the International Standard Work Code, but more recently, the Digital Data Exchange, which we'll have a separate presentation about, which is a suite of XML messaging standards for the music industry value chain. And I think somebody from ASCAP is going to talk about this tomorrow. And then a more recent one that I just found out about, the Mobile Entertainment Forum, which is intended to develop messaging standards strictly for the relationship between mobile operators and rights holders. So this is an example of how rights management information has been in development in the music industry for some time, even before the internet, because collection societies manage data, use data, and they require documentation. And increasingly, because of the internet and digital formats, this information needs to be interoperable. Other industries use metadata identifiers as well. I'll just mention one that's under development right now by the publishing industry, which is called the Automated Content Access Protocol, ACAP, and you can find it on the net. It's a technical framework that enables publishers to provide permissions information that will be turned up in searches by search engines. The bots will actually detect and interpret the licensing assertion of license permissions information, and this is intended to deal particularly with the Google phenomenon by publishers where, particularly with regard to newspaper content, if there's an assertion of the right in the form of metadata that can be interpreted and read by the bot, it's much more difficult for the search engine to rely on a copyright exception to say, hey, you're not trying to license this. There's, this is an assertion of licensing terms, and so this is something that's very interesting and being worked on by the publishing industry. Interoperability. This is an issue that really affects all information and communication technologies. It is a global policy issue. It came up in the World Summit on the Information Society, and will be in the follow-up Internet Governance Forum next month down in Rio. The WIPO development agenda calls for open standards. We haven't talked much about the development agenda, but Mike referenced the limitations and exceptions issue, which is related to the development agenda. So the whole question of interoperability is really, and interoperability and development, the need for access to technical information, technical interoperability to build industries, to build mobile phone industries, to build automotive industries, to build digital music industries is a growing international concern. In the copyright area and in the music area specifically, interoperability right now is interpreted to mean the ability to play back music files wherever accessed on the playback device of the user's choice. And this came up in a very specific context and has achieved legislative attention in the European community in relation to the Apple iTunes Music Store, and particularly the Fair Play DRM. The EU directive has language facilitating or promoting, encouraging compatibility and interoperability, but more particularly the French implementation of the 1996 treaties and the EU directive involves public authorities for the first time in promoting interoperability among competing DRM platforms in reaction to the proprietary closed nature of the Apple DRM. I won't go into it more. We'll probably hear more about it. Consumer authorities in the Scandinavian countries, where consumer protection is extremely strong, has also called on Apple to explain itself and to encourage it to consider a more open approach to its proprietary DRM. And Mihaly told me last night that in Norway, this has actually had the effect of closing the market to the Apple service. The thing is here, this is interesting in that the legislators are starting to look at interoperability, but technology mandates and legislation are very, very tricky and have a very difficult and problematic track record. You remember the Hollings bill in this country, which tried to legislate a DRM solution earlier in this decade. It's really complex, and legislation may not be the best way to achieve interoperability. Well, if it's not, then what is? So there we turn to standards. And this is another issue that is achieving a lot of attention internationally, not specifically in relation to digital music or copyright, but really in the context of the whole framework of international trade, where, for example, China has raised in the WTO, in the Committee on Technical Barriers to Trade, the issue of the so-called IPR policies of standard-setting organizations as a possible impediment to trade. And this is where technology that is essential for implementing a standard, usually covered by patents, but also software copyrights, particularly open-source copyrights, has to be declared at some point during the development process so that it can be licensed. And then second, the license terms have to be established, and the terms and conditions have to be generally reasonable and non-discriminatory RAND. But there's a lot of differences in approaches to what RAND means across the hundreds of standard-setting organizations, public and private, around the world. So in terms of rights management information, really the collecting society community, this doesn't really affect them yet because RMI standards are not technologies per se, but they are communication protocols, at least so far, for exchange of messages in XML format. And there are IPR policies, for example, DDEX policy, that follows established norms concerning disclosure of essential IPRs and licensing of those IPRs. But I raise this because it's very much in the, if you will, the development agenda framework, the WSIS framework, the international sort of openness, open standards, open access discourse. Standards are becoming central. Nobody knows what an open standard is. Everyone has different ideas. But we all like them, and we have to be really, really vigilant about what they're going to mean or what they could mean if they glom on to the very, very good work that's being done by the music industry stakeholders in regard to development of rights management standards. Finally, just a couple of issues for the future. Accessions. We're going to see a lot more accessions very soon. We're going to see more than 15 countries in the European Union come in as a bloc. We're going to see a lot more developing countries come in as a result of implementation of FTA obligations, even though they all have a time and implementation period, usually 5 years, for accession. Enforcement, we're going to see increasing granularity of TPMs. The very interesting announcement a couple of days ago about Google's new video identification service for YouTube is a very good example. It's based on fingerprinting technology. It's currently being tested by 9 media companies. So TPMs hopefully will evolve beyond some of the negative first impressions of consumers. Limitations and exceptions. We did a study last year putting out some ideas about how DRM could be used to automate access to content under limitations and exceptions. These technologies are essentially, and these information protocols are essentially technology neutral. They are designed in specific ways that make them do specific things. So our idea, or at least what the issue we wanted to begin to explore, was whether they could be designed in an appropriate way, not only to deliver content under rights with subject to compensation, but authorized transfers from authorized holders of rights or holders of content to authorized designated beneficiaries with or without payment. If the technologies are agnostic, we asked, why can't they be used for legitimate content delivery across the spectrum of protected public domain content under limitations and exceptions? This is very much a work in progress. Mike referred to the work that we're going to be doing in the Standing Committee on Limitations and Exceptions. Finally, I just want to say that we have law out there, we have the treaties, we have implementations of the treaties, we have technology out there, and we have notional aspects of self-regulation, which unfortunately in this country have not really been tried that much yet in the DRM TPM space. There were tentative nudges forward in the European side with the e-commerce directive. I won't go into that now, but particularly with regard to notice and takedown, which went nowhere. But it seems to me what we're going to need is not only law and technology, but we're going to need self or co-regulatory approaches. None of these elements, law, technology, or self-regulation, however, will be enough by itself. Thank you, Michael.
Oh, boy. Okay. I have a question right off, which is directed at, maybe Mihai or you, which is, what is the nexus between TPM or RMI and antitrust? Is there something that would not be permitted, that exchange of technology? For those of us who are laymen, what's going on here that's a problem, if anything? If anybody wants to address that.
For those of us who are laymen, what's going on here that's a problem? Is that the question?
Well, in an antitrust format.
I'm not an antitrust expert. However, I will say...
Could be a problem, sorry.
That in standard setting organizations, both public and private, are largely self-regulatory, but they are subject to oversight by the competition authorities, both in Europe and here. In fact, the FTC and the Justice Department have recently weighed in response to a request for an opinion letter and in regard to Rambus technology, the Rambus proceeding, for those of you who follow this, I know there are people here who do, about how much it implicates antitrust principles particularly on the issue of disclosure of essential technology and when it has to be disclosed in a standard setting process. Those are very much subject to competition principles. But generally, standard setting bodies are open to anybody. Any that wants to participate, you have to join up, you pay your fees, you sign your non-disclosure agreement, but then you're in. So there's no barrier or exclusion to participation in a standard setting body. Beyond that, I don't really know what to say.
Okay, that's fine. Do you have any comment? No?
Mike, I'm a sensitive soul, and I'm still recovering from the abuse of the dominant position for every time. I think standardization is, there are competition issues, and generally speaking, everyone thinks they're a good idea, and the question is, one of the problems is you get all these horizontal competitors together in a room, other things happen, and they're doing it in a way that actually there are all sorts of, they could be doing right to take a leader's advantage away by making that leader's technology the standard. It could be anti-IP, and in fact, a big debate back in the early 90s about DG13 trying to do that with regard to telecoms. But I think everyone realizes that standardization is important, and I don't know that it's a burning competition.
Okay. Sorry, yes, sir.
Jørgen Blomqvist, Director of Copyright Law Division at WIPO. I see one conflict between antitrust law and digital rights management. And that is, as soon as you have the technology that allows the right owners, for whom we can have very much respect, but if the technology allows them to write their own copyright law, in that the technology defines a de facto protection which gives much more protection than the balanced one which has been decided by the legislators, looking at the interest of the various stakeholders, consumers, right owners, and so on. If we get into a situation where the technology is actually used to get a much stronger protection than the one that was foreseen by the right owners, I definitely see an area where antitrust thinking might come in.
Do you see evidence of that?
No, but I certainly see the potential in the technology. And you do see it from time to time in a related area when computer program distributors moved away from selling their programs into licensing them. Then they started writing the laws and from time to time gave themselves a stronger protection that they would have had under, for example, fair use doctrine in this country.
I don't think there's any antitrust issues involved in that. There's policy issues involved. First, there's no horizontal or there's no vertical dominance. But what there is the issue is really should copyright laws or whatever the laws are for protection preempt contract in certain situations because it removes what someone could do under the copyright law contract. And in the analog world, it never happened because I had a lock on my store. You couldn't come in there. I had complete control. I can wrap the magazines, cellophane. By the way, in America, they think that's all pornography. But in Europe, actually, you go into Italy or some places, all the magazines are wrapped in cellophane.
They're all pornographic. Did you take that out of the tape? If you're doing the tape.
And no one can say, you know what, I'm going to rip off that cellophane and read it whether you like it or not. Well, you're not open at 5 o'clock. I'm coming in to your store to get access because you're denying me a chance to do fair use on your magazine or anything else. You switch it to the digital. Oh, my God. Yeah, of course. It's a horror. I don't know how I can cope with it. And to me, as a copyright person and someone who believes in copyright, it's just a digital excuse to rob and pillage. And I'm trying to be as neutral as possible.
Mihai?
I think that there is a clear tension between the protection of DRM, first of all, TPM, and anti-competition aspects, namely the issue of interoperability. It is the issue. The music, the artist's music store may only play back to the equipment which uses a certain DRM, and not on the basis of other equipment. Then, okay, this is a competition aspect because in this case the market is dominated, and it's not very good even from the viewpoint of owners of rights because then the company which dominates the market may also dictate the content. But how to open the system? If the system is open, which is based on the DRM, and the DRM is open, then the protection given by the DRM may be removed, offering information to the other. That's the big problem. I don't know the answer to it. If somebody solves this, then congratulations.
Isn't there an argument that the market can solve this problem to a certain extent? You have Universal, who's refused certain licenses to iTunes, and you have Amazon opening up their own online store now, and they're charging a different price, and they're getting a different price break than iTunes. So I guess the answer to that is, can market forces ultimately answer that issue rather than legislative or judicial forces?
That's the way of removing tension between anti-competition aspects and DRM, removing DRM. Of course, that's the solution, but whether it will function in the long term for everybody, I don't know.
I think there are problems with apparently you also called Mihai?
Yes, please, it's up to you. I've got some
I've known you
200
for
versions
17
of
years.
my
You
name.
never said call me Mihai. I'm actually a little offended. But Mahali, or
Up to you.
is that, you can't have, I have what basically you need the interoperability often is I have this certain technology which also allows to play some other technology. I am now trying to not only have my IP protecting in the technology of the player, but also I'm going to get an exclusive monopoly on what can be played on. And that's sort of a classic antitrust issue of leveraging, of which really courts and everyone else all stops to the interoperability. And it says the marketplace, at least in the short term, you're not going to be able to correct that.
Sir. Where's the lady? There she is.
My name is Ron Hebert. I'm with Hebert Songtown Publishing. This may not be the appropriate forum, but we're talking about the things that you've been talking about. And I have two questions real quickly. In a country such as China, which has just now signed this agreement, but is pretty well known for pretty much ignoring copyright law, who is going to enforce that in China? Number two is, the first definition is that the copyright owner should be able to say who, when, and where uses his stuff. And yet we in the United States have certain laws and time limits and frames, whereas other countries have shorter time limits and frames. And it would seem as though an example might be England has a shorter time limit for sound recordings than the U.S. does. Why should another country be able to shorten that time frame? Where could it stop? Could somebody say we could do that after 5 years?
I'm not sure. Do what after 5 years? Well. About the China enforcement issue. Richard has the answer to that. He's being circumspect.
Let's say that the legislation of China to implement the WCT and the WPBT went through a lot of consultation with a lot of stakeholders worldwide. Also remember that China, to get into the WTO, had to exceed or provide the minimum levels reflected in the TRIPS agreement, which is not the same exactly as the WCT and WPBT, which are slightly higher when it comes to copyright. But enforcement is, you don't have to prove, for better or worse, have a blue ribbon certificate of, we're good copyright cops to join a treaty. It's the compatibility of your legislative framework that determines your entitlement to join a treaty like the WCT and the WPBT. Now, having mentioned the WTO, the issue of enforcement of the rights under that treaty, under that law in China, the Chinese enforcement practices, which is a well-known concern of many rights holders worldwide, could be addressed in a WTO proceeding under the dispute settlement provisions in Part 3 of the representing the or interpreting, applying the enforcement provisions of Part 3 of the TRIPS agreement. But that would be outside WIPO. That's a WTO framework. But that being said, there's a lot of people worldwide representing rights holders. We, in our technical assistance programs, where we spend a lot of money advising countries and working with countries on enforcement practices and training, we're working very closely with China to try and make that better. You just have such a booming economy in all senses in that country, and the perfectly understandable desire, certainly understandable here in the land of commerce, to make money, has, at the same time as the sort of piecemeal evolution of the necessary infrastructure, not just legal and legislative, but also technical and industrial, to participate fully and on the basis of internationally accepted rules in international trade. It's very uneven in China, and this is just an issue that we're going to be facing for the next few years, but believe me, a lot of people are working on it.
Uneven. That is the nicest description I've ever heard.
We aim at neutrality on the WIPO Secretariat.
Do you want to address the second question about differing terms of copyright? I think that was the question, right? I think the answer is any country can lower its term of copyright, and therefore
No, but not under the limits of determined by the international treaties.
Well, in Europe, yes. I mean, you can have a longer term, I think, people think, but not a shorter term.
Yes.
So you're talking about 50 years for recordings, for example, but that's a minimum. There may be a country that has a longer term, right? Well, that's here and that's there. That's, so therefore what? Therefore?
He's here, publisher from the International Center.
Oh, I'm sorry. Where's the lady with the mic? Lady with the mic. Want to give it back to me? So we just want to clarify. Maybe this, I don't know if we're in the wrong direction here, but just to clarify the question.
Well, maybe it should. Okay. I guess the situation in the United States, if you have a sound recording, you have say a 70-year lifespan. You recorded here, you're done here. You're from this area. It's your copyright. It's taken across the river 50 years later, or somebody else puts a 50-year copyright on it.
Right.
Maybe another country decides it's only going to be 20 or 10. If it's your thing, why should some other country be able to determine what the length of your copyright is before it goes into public domain? That's the question.
There you go.
You know, the terminal protection is an exception to national treatment. If a country provides for more than the minimum terminal protection, it is not obligated to apply this terminal protection for those countries which apply the minimum terminal protection. But no country may go below the minimum. Minimum is 50 in the case of the Berne Convention.
Yeah.
There are more countries which opt for 70.
We have 95.
That's what is not very much liked here by certain academics.
We have just a couple minutes left. I would like to ask a question. I see there's one coming, but I'll be. Why don't go ahead? Ask and give it to this. Well, we have a really important question.
Yeah, Mike wants to.
This is my question, which is: it seems to me, and it's in my little paper, that the system, with the complexity of the digital issues and the huge amount of repertoire, and a certain amount, the system determines what's good and what's bad, what can get in and what can't, and what's permitted and what can't be permitted. So we have in America this enormous repertoire. It generates 70, or depending on who you ask, % of the income in Europe. If an American society turns around and says to a European society, you're the only one that's going to be able to license our repertoire. Is there some kind of an international restriction? Is there an antitrust element there? Can somebody do that? Because it effectively gives the American society an enormous lever over how Europe develops in terms of its own internal societies. I'm asking a broad-based question. But it seems to me that you could say that we control the system of the data. If we control the system of the data, then it puts other people who have various kinds of data systems in their different societies at serious risk. It's kind of a vague idea, but.
So the scenario is U.S. just said we're not going to license them.
Except through the French society.
Society.
Right.
One of the things you don't have control because it's competition law and IP is territorial. So you have to look to the law of whatever jurisdiction you're in. In Europe, you have a dominant position. And refusal to license is a dominant position. You're going to get hammered. And especially if you're collecting. You're dominant because you have all these people coming together. So you're going to have only one violation. Microsoft, you've got both laws apply. The U.S. is much milder than so I think you don't really have control in this some jurisdictions apply. That's quite restricted. And so global, even though you don't have harmonization, to some extent you have harmonization because the most restricted jurisdiction probably control the actions. And Microsoft will now change its actions worldwide as a result of this case. And it may only have to do it in Europe, but it's inefficient because of otherwise. So in the same way we would want to have protection, people may have to be worried about protection. And we need more harmonization so that we control their actions to that. So in a globalized world, the one who has the most impact can control others. So in this case, you're not going to be able to control how your respective law practices.
Could you give the mic to the gentleman?
My name is George Renee. I'm legal counsel for the Haitian Copyright Bureau, and I wanted to return from earlier comment from Professor Fixor about social deductions, and I see the copyright the antitrust flag has been raised by Mr. Sukin often against questions about DRM, etc. As a Copyright Office of a development country, we have in the national law implemented deductions, mandatory deductions, fairly low percentage. I think it's between 6 and 10% for foreign works, and in our efforts to have reciprocity agreements with foreign societies, this antitrust card has always been risen, and it's very difficult for a country like Haiti to try to enforce these social deductions. Is there any works? I know there's been talks at WIPO or maybe Mr. Batiste from the SESAC could answer that question. How does countries implement? How does it work? Implement the development social deductions. How does it work without being subject to the market leverage of societies or between countries?
In WIPO, there is a book which deals with this. It's available outside, I understand, which says that on the basis of the international treaties, it's not allowed to prescribe the deduction for such purposes, only on one basis. It is a tax. But then it's covered by the agreements on the avoidance of double taxation. If it's still prescribed, it only applies to birds protected in the country but not protected on the north. And it's a two-tier system. As regards the foreign owners of rights, it may be only a kind of style for the collective management organizations that they should try to agree this.
One more question. Michael, the lady's right behind you.
Thanks. Mike Keplinger from WIPO. It's really not a question. It's just an observation. Mihai said something that I really liked earlier in his talk.
He always does.
When he talked about the negotiation of the Internet treaties and the umbrella solution, which may have fallen down and turned into a lumpy carpet. All I'd like to observe is that had it not been for the umbrella solution, as one of the negotiators in that process, there probably wouldn't have been the treaties, where the treaties wouldn't have included protection for online distribution. So it may have made a lumpy carpet, and we may stumble a bit while we walk around on it, but at least we've got some basis for walking around and trying to find a solution, and I think for that Mihai deserves a lot of congratulations.
I think we're going to break now. Thank you all, and thanks so much for the great panelists. And coffee break?